enti na ene the breaking news abeka yensa sesia a efa eye Chief Justice Torkonoo. Yes, ono so ende obabeka sa obeka ya amanfo e the petition e the command John Dramani Mahama say eye Torkonoo yenyi nadi yen suspending free the position because of say what the kunu ene ne ma afri Ghana e de kwakopiem e woye obi man so nti yenyi nadi na asasem ne ba yen ekopiem e wo court e mo court e set committee e wo ho nyina abusuya ankosi hwe waje ase na enda de Torkonoo echire mu a se wankasa ni tiri ho abusuya ye beyi na yibone bi ho nso na enye papa enti ende o se 3 o'clock obekasa ampa 3 o'clock eduru ye Torkonoo Chief Justice or the same ababetu dwa o chire mu a ba bia omo set committee a omo de no air kono so omo enkai abakwasem a eho ana de na anke bi ekọ ho a omo ye de omo kokun no abusuya enti ende Torkonoo adi nkomo na yenti de oka.
The Edu Lodge facility that the hearings are being conducted in featured very prominently in the planning of the murder of judges on June 30th, 1981. And this can be read about in the special investigative report on that terrible event in our nation's history. It will be recalled that there was a Major Samapa, a military officer who was killed with the 3 High Court justices, who was the Director of Human Resource of GIHO. He was my uncle and my guardian when I entered the University of Ghana in September 1980. I was also living with him at the time he was abducted and murdered. Was Edu Lodge chosen for my inquiry to make me feel insecure? I think so. And I continue to hold the view that there's no reason why a judicial hearing is being conducted behind the high walls of Edu Lodge. Supposedly on subpoenas, without the issue of subpoenas, just come and swear oaths and present documents to the committee as exhibits. The witnesses themselves do not have the petition. They do not know the allegations in the petition. And so they cannot answer questions on the petition. And when they finish submitting their documents, my lawyers are called on to cross-examine them. Since 23rd May 2025, this strange process has been followed and witness after witness has been called. Like Nebuchadnezzar's situation, in which he demanded that the magicians in his court should tell him his dream and also interpret it.
And the Chief Justice H. said that na NDC for eka nsem bi say or the ne kunu afri Ghana e de kwakopiem e obi man so one ne man nyina enti yenja sa asem ne so na yenyi na di no abusuya. Chief Justice H. sa asem na omo de to ne so ni nyina e wo social media ni nyina na wate ni nyina na ende de o kan say sa asem na omo de to ne so nyina no kro bia enimu.
The clear danger is that through this flagrant violation of CI 47 and the darkness of the things being held in camera behind the walls of the Edu Lodge, my lawyers and I can come to the end of the proceedings. The evidence will show that every one of those allegations in the petitions that were given to me on 27th March is unfounded and untrue. The committee can dig up some allegation from whatever documents they claim to be having from the president, which they have not shown to me, and purport to enter a recommendation on that basis. To say that this is totally unknown in the rule of law in this country. If it was lawful, I would have no reason to alert the nation of the dangers they represent. It is the violations of law that have forced me to bring these matters out. It would be best if I just retired or resigned, rather than subject myself to an ill-motivated process. I also received threats and veiled threats to the effect that if I fail to resign or retire voluntarily, I will be made to suffer some harm or the other. I assure everybody that I am not seeking to cling to a title or a position. However, as a lawyer of 38 years standing, a judge of 21 years standing, and Chief Justice who has served the rule of law all my working life, in fact since I was 25, it is my onerous duty and obligation to speak up concerning anything that is extremely wrong with the administration of justice in this country. This is what I do every day. The situation I have been confronted with has shown me a model of injustice that I would never have thought possible if I had not been exposed to it. This is why, despite great personal discomfort, I have decided to marshal every effort in law and leadership to answer to this situation. Again, resigning or retiring while Article 146 proceedings are being conducted to remove a judge is not an option any judge or public official can even have. Founded allegations were not defended because they were true and I had no defense to them. As Chief Justice of the nation, who has been given the privilege and obligation to lead administration of justice, I should not turn tail and run when I know the implications of not defending false and unwarranted charges. Because I transferred the case in which he's a party from one judge in the High Court. That is a crime. What Mr. Ofori did not seem to know, which I stated in my answer to that allegation, is that the judge his case was transferred had a family crisis and had to leave Ghana for an extended period. Only reason why cases were handling being cases were distributed to other judges failed to retire accountable interest of $14,000 when I traveled. When I did retire that accountable interest 2 days after I returned from my journey, I was given $14,000. I could only spend $4,400, and I returned $9,600 2 days after I returned from Ghana. That in my conditions of appointment as Chief Justice, Ghana graciously gave me 2 vacations in a year. In the Judicial Service travel policy, since 2010, the Chief Justice can never travel alone for security reasons. And the Chief Justice is always allowed to travel with a spouse or another person of their choice. So traveling on my officially given vacations with my husband on one occasion and my daughter for the second vacation is part of the official conditions of my appointment as Chief Justice. I was also not responsible for buying the tickets in question, such that I could be said to have misappropriated the value of the tickets. Indeed, if the Judicial Service was not allowed to buy the tickets for my vacation, the remedy was for the Auditor General to surcharge me to refund the money. Anyone can check out the 2023 accounts of Judicial Service and know for themselves that there is no surcharge against me or anyone for the tickets that were purchased for my vacations. Ms. Ofori seems to be alleging that I should have traveled with my police escort alone on vacation and not a family member. And this is why he wants me removed from office. And I'm being tried or held behind the walls of a Edu Lodge. Ladies and gentlemen, the question to be asked is, why would anyone demand that I go on vacation given to me as Chief Justice with my police security, instead of going with my husband or my daughter? And how can this be a reason for subjecting a Chief Justice to a committee of inquiry? In the petition I received, Mr. Ofori also complains that my family members should not have been given per diem when they traveled with me, and I have misappropriated the per diem they were given. But anyone reading the Judicial Service travel policy will find that it provides that when the Chief Justice travels with anyone, whether police escort, another judge, secretary, or a spouse, that person is given pledges that I have refused to reinstate 2 members of staff whose appointments were terminated around 2015, 10 years ago, when I was nowhere near being Chief Justice, and whose issues are still being heard in court. He goes on to allege that I should be removed for terminating the appointment of 2 staff members who went through disciplinary proceedings that were initiated by reports against them before I became Chief Justice. Though it is not clear to me why Mr. Ofori should demand that the Chief Justice should be removed for transferring a member of staff or be the final authority to sign any termination letter, I handed over to His Excellency the President records covering every administrative step on these matters. Another allegation of Mr. Ofori is that I appointed the former Judicial Secretary as Judicial Secretary when she was a judge, and so I have made her inefficient. Now, anybody who cares to know the records which I handed over to His Excellency the President was that she became Judicial Secretary in 2018. She became a judge in 2019. I was nowhere near being Chief Justice. I was appointed in June 2023. Ms. Ofori also alleges that I have appointed judges as registrars, and this has introduced inefficiency into the management of court. He complains that I supervise the Judicial Secretary to administer a decision of the General Legal Council, which was taken before I became Chief Justice. He complains that I recommended judges to be appointed to the Supreme Court, so I should be removed as Chief Justice. Now, anyone who knows how appointments are made with recommendations from the Ghana Bar Association, the Attorney General, and the Chief Justice will know that this last complaint only shows ignorance of a very long-standing tradition. It has been the settled practice for decades that in the recommendation of justices for the superior courts, it is the Chief Justice, the Ghana Bar Association, and the Attorney General who have the privilege of making recommendations for those who are to be nominated. The recommendations can be refused or accepted by the President. So a petition from a gentleman called Mr. Ayamga Akogo, his complaint is that on 14th November 2024, after the Supreme Court had given a ruling which went against him, I, as presiding judge in the Supreme Court, ordered his arrest without any reason. He attached an exhibit to his petition, which was a media report from a group called the Law Platform. This media report says that after the Supreme Court panel had ruled against Mr. Akogo, he started to shout in the courtroom, and that is why he was taken out of the courtroom. Essentially, therefore, his own exhibits contradict his claims. Mr. Akogo goes on to claim that when he applied for a copy of the day's proceedings, which were signed by all the judges that presided on his case, he did not see a record that he had been arrested. So I should be removed as chief. What is significant about this petition is that Justice Puaman sat with me as one of the judges who heard Mr. Akogo's case and was named as a witness that Mr. Akogo will call. But His Excellency the President has appointed him to chair and inquire into this petition, and he has accepted to do so. That during the hearing of the case of Afenyo Makin versus Attorney General and the Speaker of Parliament, when I sat as a judge, I failed to hear the side of the Speaker of Parliament before the Supreme Court made an order, so I should be removed as Chief Justice. Again, I can only point to the fact that no judge sits alone in the Supreme Court, and the court's decisions are the decisions of all the judges who sit. Interestingly, There have been some recent suggestions about rules being made to safeguard judges from frivolous attempts to remove them from office. It sounds like an attempt to assure the judiciary that after unconstitutional and illegal means have been used to remove me, conditions will be made safer for those who help with it or those who may be afraid by the current occurrences. Despite the interesting new discussions of rules for removing judges, I am convinced that it is only a matter of time for the nation's democracy to experience the bitter harvest of what I am reporting.
And he said the empanifo ekase insuo eta ponchani a oje o what you say eno na eye chief justice and the opulini nyina gumonten de wo mu bia na waka to ho no what you say because who say ba bia ekone de ani eya yenyan abusia mame hu adwenkyere e wo comment section o wie nsu ani de mu na wa subscribe na wa share wa like said the afofro nso ebenya bi atie kete wo say enye dodo no nwura makra baba.